Next, we'll move right along to a real great bill sponsored by myself, Representative Batista, Baya, Slater, and Felix. It's House Bill 5264. This act would clarify any disability or quarantine resulting from COVID-19 or any other viral infection classified by an executive order during a state of emergency as an occupational disease in relation to workers' compensation. The Act presumes that the COVID-19 infection occurred due to the employment duties and interacting with infected members of the public. This Act would apply to health care workers, direct support staff in healthcare settings, public safety workers, and essential workers such as grocery and transportation workers. The positive infection must be established through a positive test or a positive diagnosis by a licensed physician, and proof of virus positivity must be provided to the employee's employer. In order to refute that the positive infection resulted from employment duties, the legislation calls for a predeterminance of evidence presented by the employers that the infection was caused by non-employment connected risk factors. These dedicated workers from all walks of life have literally kept our society in operation over the course of the last year plus. They risked the health and safety of themselves and their families so that the rest of us were protected and supported during the pandemic, and it still continues. It is only fair and right that they be allowed to receive workers' compensation benefits if the worst were to occur and they became infected, resulting in serious economic consequences for themselves and their families. These people did so much for all of us during the pandemic, and we owe it to them to see that they are cared for and supported if they too should suffer the effect of COVID-19 after putting themselves in harm's way for all of our benefits. And that is my testimony, and I'm sticking to it. Are there any questions? We have Mr. Christopher Carlozzi. Is he on the line? Okay. Good evening, Mr. Carlozzi. Welcome to Labor. The floor is yours.
Thank you, Madam Chair and members of the committee. My name is Christopher Carlozzi. I'm the State Director for the National Federation of Independent Business in Rhode Island. We represent small businesses in a wide range of industries, including retail, wholesale, hospitality, service, manufacturing, agriculture, a wide range of industries that have been heavily impacted by this pandemic. A lot of these businesses seeing a reduction in revenue, unfortunately having to lay off workers in cases, reduce hours. They've been struggling to survive at this point. But we feel that this bill, House Bill 5264, we have some concerns with it, and that's that workers' compensation insurance does not usually cover community spread illnesses because it's very difficult to connect them directly to the workplace. And while workers' comp is meant to cover incidents and injuries within the job, and when a worker is injured or contracts some sort of occupational disease, it can be proven or shown to be job-related. But because of the highly infectious nature of COVID, it really means that a worker could have contracted it anywhere, not necessarily the workplace, and proves that it is difficult in many cases to show that it was contracted on the job. In fact, an example of that would be that over the holidays, in informal settings, is when states saw the biggest spikes in recent weeks in some of the COVID cases because people were gathering informally, not necessarily in the workplace. Businesses have taken every step imaginable to try to ensure that workers and consumers are safe within businesses. That includes masks, distancing, PPE, plexiglass, all the things we've seen done over the last year to keep workers and customers safe going into businesses. But this legislation could result in higher workers' compensation rates for a lot of businesses in Rhode Island. And these businesses are already struggling at this point. As I've just said, they're spending money in areas they didn't spend money in before for increased cleaning and some of the PPE, and as well as seeing their revenue drop over the last year because they've had fewer customers come in the door. Some of them have been hit by the restrictions. Some of them had to close during the pause. So there's been all sorts of things that have been impacting these businesses already. So workers' comp rates going up, it would be very problematic for them at this point. And it would be, I would also say, unfair to them, having taken all the necessary steps, taking those steps and precautions that the state has mandated over the last year, that their workers' comp rates would have to rise due to incidents that may or may not be directly tied to the workplace and very difficult to prove. They've been trying to keep their doors open and keep in business and keep workers employed for this past year, and it would be difficult if costs start being piled on. So while COVID is particularly highly infectious and the possibility of contracting it anywhere from a bus to carpooling, a family function, a park, a doctor's appointment, really anywhere, we do feel it would be unfair to penalize businesses for something that cannot be definitively tied to that business and could result in higher workers' compensation rates for those businesses. Right now, of course, Rhode Island is struggling with somewhat high unemployment. We just don't want to do anything further that would harm a lot of these small businesses that have struggled, quite frankly, in the last year to keep their doors open. So I thank you for the time today, and we did submit written testimony as well on this topic.
Are there any questions? Representative Kazarin.
Thank you. Oh, thank you, Chairwoman. There we go. Thank you for your testimony. This pandemic has been very hard on a lot of our businesses here, and we certainly don't want to put more burden on them, but we also have to protect our workers, the people that are going into work every day, making sure that our economy is still going. One of the things you mentioned is that it's really hard to say where somebody got contracted COVID from. But a lot of these diseases that I'm seeing already listed in this bill, which means that they're already current law, it's on page 1, lines 9 through 18. Or no, sorry, keeps going. Continues on to the second page. A lot of these things I think would also be difficult to necessarily say whether or not you contracted it at work or another place. So I do think COVID is appropriate to add to this bill, and I again commend the chairwoman for sponsoring it.
Thank you. I have a couple of comments as well. First and foremost, I have to give Mr. Christopher Carlozzi a special welcome, simply because that's my friend.
Good to hear you as well, Madam Chair.
Yes, I was wondering, I'm like, wait a minute, we had that 4,000 or something like that conversation a couple of years ago or so, 4,000 versus 14,000.
It seems like a lifetime ago at this point, Madam Chair.
Yes. So I just want to touch bases on your comment, and I greatly appreciate you standing up and representing all your clients, which is very admirable. But first, I would like to say there is nothing in this bill, it's not my intention in any way, shape, or form to harm any business, small or otherwise. And it's not my intention to penalize them either. There is such a thing that we all here have been hearing for the past 11, 12 months. Contact tracing. So that is something that we are supposed to do, especially if we are working in an environment where we're trying to make sure that we don't get infected, or we have to be careful for an array of reasons. So it's not very hard to trace if you're doing your part. And I know and understand that businesses are struggling right now, but that is more reason for them to really pay attention to their staffs. It's extremely important. It's a two-way street for the employer as it is for the employee. And you made mention that businesses have taken the necessary precautions. Not all businesses have done or are doing what they're supposed to do when it comes to their employees. Many have gotten better, but all are not complying, are not doing what they're supposed to. So we have to protect these employees who are coming out every day, one, because they need to survive themselves, and two, because they're doing us a service, us individuals who are privileged to a degree to be able to stay home and not worry so much about having to go out and be in the environment of this pandemic. So I would just say, welcome, and we can continue to discuss this, but as always, people first in my book, and the safety of those who have and continue to put their lives on the line for the betterment of us deserve our attention and our support 24/7. Thank you. Are there any more questions? Or would you like to say something? Representative Morgan.
Yeah, is Gail Wolfe from Beacon Mutual going to be testifying?
She is not on the list.
Because she submitted some written testimony, and I think she pointed out some real issues with this legislation that we probably should take note of. One is that the legislation includes police officers, firefighters, who are already covered by injured on duty statutes. So it actually may not be to their benefit to be included in this legislation, because IOD gives them all of their pay,
Okay.
and their benefits continue to be enforced while they're on IOD. So it probably is something that they would welcome in this legislation. She also mentions that the legislation says, and any other viral infection. Well, that could be shingles. Oh, great. My computer. Shingles, herpes simplex, it could be a common cold.
But it says clearly that it would be called of a state emergency. I'm certain that the shingle
Okay.
is not
And
a state of
I didn't see
emergency.
that distinction, Chairwoman. But you wouldn't, if there was a measles, like a measles outbreak, God forbid, or something like that, it might be better just, I think the testimony is saying it might be better to just rein in the definitions here. And then she also mentioned that even through all of this, the pandemic, the Workers' Compensation Court has been meeting. And if somebody can demonstrate that there is a causal effect between their employment and them getting COVID and getting it so badly that they are then injured and have a difficulty returning to work, that if they can, if they can demonstrate that, then they do get work.
No, that's not
benefits.
correct. That's not correct. It's determined by the current law and the judge in that specific moment, how he's interpreting that law. So it's
Well,
not as
it's-
easy as you are putting it for the individual to prove, and then they get the workman's comp. It's a lot more complicated.
So are you assuming that just anybody who gets the coronavirus should get workers' compensation benefits?
No assuming, no assumption. You know what that says, baby. No, baby, no. I'm talking about the real deal, these individuals who are out there who contracts the virus, and individual employers are negating them from filing that they caught it while on duty. There are some folks that are, the bad apples that are out there doing, but you have to definitely, your contact tracing, definitely, if you have that and you can definitely provide it, your employer should not be denying you that benefit at all.
Yeah, and I think that's what this testimony from Gail Wolfe is saying, that the court is there, it's still meeting, it's still taking these cases.
Yeah, and they're not, and they're.
Contact tracing.
You have to understand, if the court was in fact doing its due diligence, this legislation would not be needed. What the court is doing is basing their conclusion on current language. Nobody anticipated this magnitude of a virus to come and attack the whole world. So, what are we supposed to do with these individuals who are putting their lives in the front for us? What are we supposed to do? We're supposed to take care of them. Are any of us, is Gail Wolfe and her client willing to step up and do what they're doing? I understand that people are not embracing the fact that, these individuals, many people are getting this virus. Not because they're being careless, but because they're doing a job. Like I said, there are some Joe Rockheads out there, and rightfully so, they're going to try to, work the system. But current law does not permit the judge to realistically put a claimant as easy for an individual that has contracted the virus through its employment. It's not as easy as that. They're reading it as it's written, and it has no corona in it, and this is a state of emergency, and there are a lot of people who have died, and there are a lot of people who have caught it, and they're without any recourses, financial recourses, because they're individual employers that are saying you could have caught it anyway, anywhere. Yeah, from my house to your business is where I caught it, and I brought it back home. So I understand and I respect your concerns and your points that are made. And
No,
what,
I just read her testimony, and it seemed to be saying they still are hearing these cases. It's too bad she's not on the phone so we could ask her.
yeah. So
If I could, just chime in and I know it wasn't really a question to me, but part of the problem is that it's a presumption, that it presumes that it's in the workplace. And I think that's where it goes a little beyond, what was just discussed, that taking place in the courts. It makes the presumption and puts the onus on the employer. I think it's Section D of the bill, that it's the onus is on the employer to prove that it did not, that it was not contracted in the workplace, and I think that's part of the problem. And what Representative Morgan just referred to, that certain cases are taking place where there is definitive proof, which is certainly a valid concern and something that is allowing the courts to play out the process. But just our problem is that it would presume that it was necessarily caught in the workplace or contracted in the workplace, and that presumption is what is problematic for us.
yeah, so it's pretty much like saying the honor system is thrown out to the wayside because of the fact that just because that word is there and the employer is not ready or willing to take on the responsibility, then, it's not real. But nevertheless, I'm taking up for my people, like always, and I really appreciate the both of you, like always.
It was a pleasure speaking.
Go ahead.
It was a pleasure speaking with you, Madam Chair, and the committee, and we're certainly willing to work with you moving forward.
I look forward to that. So, I'll keep it in mind, especially it would be wonderful to see you again.
Absolutely. Can't wait to get back in there.
All righty. Thank you so much.
Have a great night.
You too. Representative Morgan, thank you as well. And that concludes the hearing on 5264. But I would like to stay on, if there's no one else on the line, I would like to stay on with the committee. I have a couple of things I would like to speak to you all about. The IT, can we have that? Make sure that everybody's offline that doesn't belong on here. This is a... Yes, I just want to say that first. I just want to make sure that everybody's on there still. That's on, and not going to be jumping off. I will entertain a motion. Oh, you say 1 second. Huh? I'm going to entertain a motion for adjournment first. Motion made by Representative Corvese, second by Representative Nadillo. All in favor?
Aye.
Any opposed? I'm sure not. Okay, thank you.